and learned speakers to webinar being organized by corporate professional as part of its knowledge initiative. Friends, corporate professional as a part of knowledge sharing initiative has always held a webinar on recap of regulatory and legal updates in companies, securities and insolvency law during the last month. On the first Friday of every month, this time we are uh, preponing the webinar from the first Friday of April to the last Friday of March 2023, because on 7th April, the first Friday is a public holiday. So that day we will not have any program. Friends, the objective of the webinars is to take up and discuss all the regulatory and legal updates during the last month in one go. So whatever new things has come relating to law, relating to case law, relating to various amendments, that changes and their complexity we are discussing with the participants, and whatever their queries is, we are solving it. Now, after reading the law, we are ourselves creating some queries and putting in our presentation. But in case some new aspects that participant can ask us, so please send us any query relating to the amendment which has taken in the last month. All the updates will also be available in our monthly newsletter CP Connect, which we are sending to all, including all the participants also. So sit back and relax and don't forget to ask your question in the chat box. We will be having a question answer session at the end of the presentation, and we will discuss threadbare on all issues which have come during last month. Today we have eminent speakers with us. We have Ankit Singh, Head Corporate Affairs and Compliance, Corporate Professional. We have Mr. GP Madan, Founder, Madan Law Office, and eminent task force co-chair of ASSOCHAM. Mr. Manoj Kumar, Partner, Head M&A and Transaction Advisory, Corporate Profession. We have Ms. Niti Mangla, Manager, Capital Market Service, Corporate Professional. We have Mr. Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation, Corporate Professional. So we have the people from all fields, those who are discussing, like company law matter, Ankit Singh will discuss, securities law and SEBI board meeting, which has here day before yesterday, they have come out so many amendments and so many few changes that Niti and Ankit Singh will discuss. Securities law, there is a various circular on securities law. Niti will discuss. Securities law, master circulation on surveillance, Ravi will discuss. And insolvency law, case law, Madan and Manoj Kumar will discuss. Now, in company law, we have very few changes. Security law, SEBI board meeting, they have come out so many things. Then there's a SEBI circular, then master circular on surveillance and insolvency. Now, these are the changes has come in the last month, first Friday of the last month to today, till today. Whatever new changes has come, we will discuss. Friend, program structure will be there. First, Ankit Singh will start. Then Niti Mangla will take up securities law, and in between some questions will be there. And then Master Circular Ravi will discuss. And then insolvency, there are three important case law that Mr. GP Madan will interact and discuss with Mr. Manoj. So let's start with this month's changes. First in company law. So over to you, Ankit. Please start with this, and then some changes in the securities law relating to board meeting. So there are some corporate law connected things, LODR. Please discuss. So Ankit, over to you.
Good afternoon to everyone. I hope I am audible. So
speak a little bit louder, please.
Yeah. Okay. Good afternoon, everyone. So to begin with, starting with the changes in the corporate law under Companies Act, I think there was one notification by the Ministry of Corporate Affairs. Shivam, if you can change the slide.
Your voice is echoing. Just can you correct it?
My voice is. I will try. Shivam, can you change the slide to the relevant slide?
Yeah, slide is changing. Yes, yes.
So I think by way of this notification, the ministry has set up a center for processing accelerated corporate exit. And this is the name of the center located at IACA. Though much detail is not available apart from the notification pursuant to which this center has been established. But from the title of the center, it appears that akin to CRC, which is a centralized center across India in the IACA, which looks after the incorporation of all companies and LLPs, similar to which has to a large extent expedited the process of registering the company or LLP. Bearing the current issues which are there in the version 3. MCA now also aims to establish a similar center for accelerating the exit. So if a company wants to close, so by way of either by way of striking off or by way of liquidation under the Companies Act, then they would be definitely be filing certain applications, or the applications they would be filed by them would be processed by this CFACE center. So this is the information that is what we can make out of from the notification. I think further details are yet to be out in terms of how the center will work and what all corporate exit related compliance procedures it will handle. So we wait for the same, but it appears a good move on the line of CRC. And I believe that it will definitely fasten the time that currently is taken in under the strike-off process or other forms of liquidation under the Companies Act. Next, Shivam. Next. So going ahead in the
Ankit,
yes.
Is
Yes,
somebody logged in with the other device in your room? There's some disturbance which is coming.
Let me check.
Your voice is also not clear. No voice. No, you have to unmute yourself. Ankit, no voice. Yeah, please start. Ankit, in the meantime, what I suggest, Neeti can start other than ESG. Neeti, you please start. Ankit, you join. So what Ankit, because yesterday on 29 there was SEBI board meeting, and they came out various suggestions. So the ESG related thing Ankit will cover. Till the time other things Neeti will cover. Neeti, please.
Yeah. Hi, everyone.
Yeah, Neeti, start.
Yeah. Hi, everyone. Neeti this side. SEBI and its board meeting held on March 29 have approved many major decisions. Basically, during the financial year 2023, in this financial year only, SEBI has come out with lots of consultation paper on ICDR, on debt securities, with regard to governance norms. So now at the end of the year, SEBI has approved many of the major decisions. firstly, we are starting up with amendments in SEBI LODR regulations, which pertains to disclosure of material events. SEBI in November 2022 has come out with consultation paper on disclosure of material events under Regulation 30. So first decision approved is with regard to introduction of quantitative threshold for determining materiality of events or information. This particular amendment pertains to determining quantitative threshold for disclosure specified under Part B of Schedule 3 of Regulation 30. That is, events which are to be disclosed to the stock exchanges on applicability of criteria of materiality. These disclosures are not mandatory disclosures. They have to be disclosed on the basis of materiality policies. And generally what companies do, they keep their material policy very open-ended and very general. So SEBI in its consultation paper proposed various threshold limit with regard to wherein if the company meet out those threshold limit, then mandatory disclosure will be required. I'll just brief you with the threshold requirement. That threshold requirement pertains to 2% of turnover of the company, or 2% of net worth of the company, or 5% of 3-year average profit after tax, whichever is lower. So if any event which meet this any of the threshold, then disclosure is required to be made. Specific threshold will be specified in its SEBI in its separate notification. Moving on to the next decision, stricter timeline for disclosure of material events information for which decision has been taken in the meeting of board of directors and which are emanating from within the listed entity. So again, this particular point pertains to Part A of Schedule 3 of Regulation 30, and SEBI has specified timelines, have basically reduced the timeline for disclosure. So basically, currently the law is that items are to be disclosed within 24 hours from their time of occurrence. Now this has been reduced to 12 hours for the items which are emanating in the listed entities, like items which are being approved by the board only, by the listed company only, like acquisitions, agreement wherein listed entity is a party, which emanates from the company is required to be disclosed within 12 hours. Rest of the items which are outside the listed entities, like resignations, any agreement in which listed entity is not a party, award, bagging award or order, all these items, all these events in which listed entity is not a party, those are to be disclosed as per the current timeline of 24 hours. Further, under the current provision, some of the items are mentioned in which is to be disclosed within 30 minutes. Now it has been specified that every item which is being taken in the meeting of board of directors is to be disclosed within 30 minutes.
Neeti, these timelines of 30 minutes and 12 hours are from the day closure of the board meeting or time of the decision?
Closure of the board meeting, sir. For financial results, it is when the financial results are concluded, and for all other items, it is from the date of conclusion of board meeting.
Okay.
Now, with regard to market rumors to be verified and confirmed, denied, or clarified as the case may be. Currently, what Regulation 30 says that listed companies at their own initiative may clarify, deny, or confirm the market rumors. Now, since social media is being so much active and most of the investors and market participants rely on these information and they are quite sensitive to all this information, it has now been made mandatory for the top 100 listed companies to verify, confirm, or deny the market rumors with effect from 1st October 2023. And for top 250 listed companies, it has been made effective from 1st April 2024.
Okay, Neeti.
Yes, sir.
Madan and Ravi, I have a query here. Now they have made, though if you remember, we have a program And in that program, I suggested the same thing, and SEBI has taken this point uh, from our suggestion, or their own thinking was going on. But it is a welcome move. Now, there are two, three things are there, because in my last webinar, I discussed suggestion as well as some issues also. How to keep track, number one. It means the company, the top listed company, they will search the entire system of all social media, Telegraph channel, WhatsApp group, and all these places, because rumor can be placed anywhere. So I think when SEBI will make rules for this, they have to clarify that what are my scope, what are the company's scope to check. If you are giving any power which is not controlled, then any scope which is not controlled, then company will face problem. So I think if there's a WhatsApp group between a few people, the company cannot get information. And
Sir,
that-
just to add, I think this is on mainstream media, not on WhatsApp. Rumors should be on the mainstream media.
But mainstream media, I think that has already been taken care of SEBI. The moment something comes up in any of the newspaper, I think on
So
the
that is
very-
the, I think in the discussion paper itself, it is mentioned mainstream media.
that's
Because
fine.
I don't
But
think, sir, WhatsApp group rumors needs to, it's impossible to verify, actually, to find out and then to verify.
No, Ankit, my question is, the moment any grapevine or any rumor or any hypothetical item is there in any of the newspaper, I think the very day stock exchange writes to the company concerned, and company has to clarify on that particular rumor or whatever
Sir,
they have been
but
exchanged.
but that is not in every case. Only in cases where stock exchange asks, and stock exchange doesn't ask in all the cases. And now they have shifted to obligation from the stock exchange on the company itself, that you need not to wait for the stock exchange letter seeking clarification. You have to clarify at your end. Though there are logistic issues connected with it, but the onus of now clarification is specifically being put on the company.
Okay,
Onus of clarification was.
let me rephrase this. This particular point has come. What is the origination? Origination is there are so many companies which are coming out with information which are not sustainable or which are not correct. Some rumor is coming, investor is purchasing shares, and the rumor, that information is not correct. So this is mostly happening in the low price shares. This is happening other than this 250 listed, top 250 listed company. Majority is taking place on other shares which are not in limelight, but somebody is doing. So the point is, this is right, but what I'm saying, they should specify the mainstream media, that is okay, but the culprit is somewhere else also. So they have to bring out the place where the company can easily reach, easily can put the system and get all the information and clarify it. So if the company is clarifying, it means the normal investor or small investor will not buy the shares on that news. That is our point. So this is a welcome move, but it requires something more to do. Ravi, you want to say?
Yes, I wanted to add just one liner from the last program. Your statement that you made in the last program, we held on the regulatory updates and probably on the FUTP aspect. You recommended that why there should be unsolicited messaging or promotion by anyone who's not registered with SEBI or who's not a registered intermediary. So therefore, there need to be a check, because once even mainstream media cannot be defined with certainty or a clock-like precision. Oh, YouTube, would you consider YouTube in a mainstream media or not? Because YouTube, people are going on YouTube and watching influencers, making their investment decisions, maybe not making them exactly, but their decisions, they get influenced by these videos and these solicitations. So therefore, I think as a rule, they can also curb the origination at the source itself. And that's another way to look at it, because it is impossible for companies. Else you'll have to set up a department who continuously researches on what is published and then identifies whether it is false or not, to what degree, and then issue clarifications. I think you made a seminal point in the last program itself.
As a market person or the active person in the corporate law and market, I have suggested that anybody who, first of all, nobody can recommend any shares if he is not registered with SEBI. Number one. Number two, if you are giving any information, you are not supposed to give any recommendation till the time you are registered. And if you are registered, then you should record like SDD software of insider trading applicable to all companies. Same thing you will also feed that I have given this recommendation and I am holding this much of shares. So the point is, in place of putting burden on companies, so companies can do this on where they can reach. But if you can plug these people, I think that will be a larger implication and better implication. Your view, sir?
I think, don't you think that the background of this particular proposed or say the discussion paper or notification is Hindenburg report?
No, it is not. It's a various cases. Hindenburg report is different because that is not some rumor. That is, they have told that company is doing this thing wrong. So that is specific. But recently one case has come where SEBI has passed an order where the YouTube channel person was saying that company has 5G license, company has tie up with Adani, company has doing this. That was the information which was going on.
No, even if a report is coming out from some organization, that report may be on the basis of the study of that organization, but then the study may be absolutely wrong. But for the market, it remains a rumor only till the time the company confirms it. And the wording which is used here, I think on the basis of this decision of SEBI board meeting, now we are going to see the changes in the regulations. Am I right or not?
Yes, you are.
For that also, I think we need to suggest SEBI, because the language, if you see in C, is it written, market rumors to be verified and confirmed. Company cannot verify these rumors. Company can say yes or no. But if you say the verify and confirm, denied or clarified, I think in the regulation, such language should not be used. This may be one of the suggestions from our side. And if I remember correctly, recently there was some rumor with respect to GST, that in case of restaurants and all that, where they are registered as on the basis of the consolidated use and all that, within one day, then this WhatsApp was spread like anything, and within one day, GST department itself came out with a clarification. So in that scenario, Ankit, my take is it cannot be confined to mainstream media only. And number two, the clarification which is being sought from the company, it should be like this. Either if the company comes to know about any rumor, the company may give the clarification, or on being asked by SEBI or the stock exchange, the clarification should be there. But if a SEBI or stock exchange do not ask anything, and a company does not clarify, there is a possibility company does not come to know about that. The company, no action, no penal action should be taken against the company in that scenario.
Yeah, that's
Sir, what about the situation where such clarification or such confirmation by a company will lead to botching off of the deal? If some transaction is being undergoing, there are discussion being done, and some newspaper reports that this deal is being undertaken or blah blah blah, stock exchanges reaches out to you. You have left with no choice. You have either say that
you can simply say it is under consideration. No final
so even now, once you say that it is under consideration, it means that you are some way part of that. There is something which is ongoing. So there may be cases it may botch up the deal. It may botch up the deal.
Sorry, Ankit, in that scenario, you have to see the LODR, whether such a even consideration is covered under LOD or it needs to be intimated to the exchange or not?
Sir, so the expert regulation 30, when or even the FAQs it issued, when there is very high chances of something getting concrete or finalized, then only you need to inform. So, but if there is a rumor and you are asking me to either deny or clarify, because if today I deny and I enter into that deal couple of days thereafter, then the exchanges will come back to me and say, boss, when we clarified with you, you said nothing is going on, and now you have entered into this deal.
Then the answer to that be the very initial stages of discussion, that's all. And initial stage of discussion, each and every discussion need not be intimated to the exchange.
So that is what, if it case in comes out in the media, that is what the exchanges might ask you. And now even the exchanges, you are duty bound to
Ankit,
clarify.
Manoj has point, because Manoj is doing takeover offer, and in the takeover offer, companies are talking to various people, doing due diligence. So subject to due diligence, then they will take the company. So what will happen, Manoj, in these cases?
So yeah, so it is very complicated situation. In, let's say we are talking about some takeover related deal. So this deal may not be between the company. Company may not be a party to that transaction. So in any case, it will be the proposed transaction between the promoters of the company and the some buyer. So, and there will be obviously a non-binding agreement, a non-binding MOU or a term sheet, based on which due diligence process is on, or negotiation on the terms of the share purchase agreement is going on. In such scenario, if it is leaked or someone says that, let's say ABC Group is acquiring XYZ, and XYZ is asked to clarify it, how can XYZ even discuss it? They don't have any official information regarding the same. So that situation, even if they are knowing that the promoter is negotiating with them, they cannot disclose it, because it is they are bound by non-disclosure agreement. So this kind of situation may happen, and there cannot be any hard and fast rule. Even the SEBI's consultation paper, which was saying that if there is a high probability of getting materialized, then you should disclose. That fact is that proposition may not be correct in legal terminology, because till the time the definitive agreements are signed, and the matter is, let's say, if it is required board's approval, it goes to the board and board approves. Then we cannot say what is the probability of the transaction getting through. All negotiation is done correctly by the parties, but the board or the audit committee may reject it. So how can we expect that all the matters which are negotiated by the managing director or the management would be approved by the board of directors? Are we assuming that the board of directors is not functioning in independent manner? So that this kind of proposition is, I don't think it is correct to say. So in most of the cases, company would deny in any case. And then when the formal agreement is signed, it will accept it. And that is happening in all the cases.
I have one more submission here, that each and every communication from the exchange to the company and each and every reply of the company to the exchange should not be hosted on the website also.
That is also a thing. Sometimes it is now a normal process that whenever news comes and there is a stock exchange seems irrelevant, then they send it for clarification to the company, and then company is supposed to accept or deny it within let's say by first half or by 2 hours, whatever time they give. It is very difficult, and all those things are placed before the public. So these are, if it is denied, let's say a transaction is actually negotiation is actually going on, and now the company is compelled to deny it, and after 6 hours, let's say they have to accept it. So this will also give the wrong impression to the market. So I think there is very thin line difference, and that what is rumor and what is actual thing.
And I think there would mostly be
companies are having a materiality policy. I think stock exchange should also have a materiality policy. What is to be hosted, what is not to be hosted on
It is right.
the website.
This is good move, but it is required certain guidelines. So people should not face any.
Fine tuning, perfect screening.
I think, sir, there will be tailor-made responses. Company continues to evaluate opportunities available in the market.
Yes, that is a standard thing which they can give, nothing more than that.
But they are saying some wrong information is coming, which is not there. You have to deny.
Yes, then we can deny. Yes, if something is totally unconnected, uncalled for, never discussed, that kind of rumors may be denied, like in case of what we were discussing, SEBI order. X company entered into agreement with Geo or Adani Group and getting such and 500 crore fund, etc., etc. These kind of false rumors may be totally denied, but rest of the things I think is fine.
Okay, next. So Niti, next.
I think on this, there is one question also on this, whether it's giving importance to rumors justified and asking companies to respond. This is
In a sense,
Mr.
in a sense,
He's an independent director on the boards of number of companies. It's a very valid point.
Because now it has come, so the discussion will take place. So let's evolve this. For Niti, next.
Yeah. The fourth proposal which has been approved is with regard to disclosure for certain types of agreements binding listed entities. This items is contained in Part B of Schedule 3 of LODR regulations, wherein this materiality policy criteria for materiality is to be applied and threshold has been specified by SEBI. Now, these type of agreements are the agreements wherein listed company is a borrower. So now SEBI in its proposal have approved that under this category, agreements wherein listed party is a lender will also be considered and will also be required to be disclosed. So all the agreements which are binding on the listed entities and wherein listed entity is a borrower or lender will require to be disclosed to the stock exchanges as per the materiality threshold. And further, it was clarified in the consultation paper that loans given to wholly owned subsidiaries and loans given by NBFCs and banks will be out of the purview of this disclosure. Yes, moving on to the next proposal. SEBI, this is with regard to strengthening corporate governance norms at listed entities by enhancing disclosure and empowering shareholders mechanism. This, with regard to corporate governance, the SEBI has come out with consultation paper in February, and some of the proposals has been approved. Firstly, with regard to periodic shareholders approval for any special right granted to a shareholder of a listed entity to address the issue of perpetuity of special rights. As we have seen that the company enter into various investor agreement, and pursuant to these investor agreement, investors have some special rights attached with them, maybe with regard to veto power, with regard to appointment of director on the board, with regard to their affirmatory voting right. All these give them the shareholding in the company as well as vote special rights in the company. And for this, company generally has to amend their articles of association. And what happens is that if the clause is there in articles of association, and that usually remains to continue, and it is generally, shareholders does not notice that thing, and it is now has been proposed that all these special rights granted to any shareholder or any investor have to be periodically approved by shareholders and to review their duration or tenure. Secondly, with regard to strengthening the extant mechanism of sale, lease, or disposal of an undertaking of a listed entity outside the scheme of arrangement framework. As schemes of arrangement are being approved by the court, by shareholders, so there is no discrepancy in that. This point pertains to slump sale of any undertaking of a company. In this, simple shareholders approval is taken. Now, what SEBI has proposed in is consultation paper to empower shareholders, they have put in the additional voting condition wherein the vote casted by public shareholders has to be more than the votes casted against it. So this is again a corporate governance move and for empowering the public shareholders of the company, wherein the unit or division of a company is being sold or sent or put on a lease or disposal.
Niti, Manoj, can you just explain these A and B part, that what is the logic, why this is happening? Because when SEBI is bringing out, you are because of some reason. So what is the logic in these two cases?
Yeah, so first is with respect to shareholders agreement. So there are cases where shareholders enter into some kind of agreement among themselves. Let's say there are two groups of promoters in a company, and they have inter se rights and obligation divided between them, the two groups. Then in such cases, these agreements, there may be, the company may not be a party to those agreements, but certain rights are granted to certain class of shareholder, and right now there is no specific provision, but to enhance the governance structure, now it is required that such shareholders agreement should be placed before the shareholders for their approval, and that to be on regular basis. So periodical basis, this will go, and so that I think that is a good move. Another one, the B1 is relating to sale, dispose of, or lease of any material undertaking of the company, if it is outside the scheme of arrangement. So if for a scheme of arrangement there is a specific law which requires approval as per the Companies Act provisions, which is a dual test, special resolution with simple majority of the person present and voting. That is one part. Additionally, SEBI has already put a clause that in case a listed company is involved and the promoter holding is increasing, in that case, majority of minority is also required. So approval from the public shareholders other than the promoter group would also be counted, and it should be at least more than the half of the total public category persons voting in the meeting. So that protection is already there. So all those cases are already protected. Now they are talking about the cases where scheme of arrangement is not there. So there are situations where companies transfers or sales entire assets or substantial assets without with a special only ordinary resolution as per the company law. But now they are saying in such cases also you should place before the shareholder, and shareholder would pass a resolution in which promoter group would not participate, or their vote should not be counted towards the approval. So that I think it will increase the governance standard, and obviously it will be now these matters which is being debated by proxy advisory firms. Now they will get settled that at least public shareholders have more say in these kind of decisions. So it is a good thing, I think.
Okay, Niti, next.
Now, with regard to timely disclosures, SEBI has approved the decision with regard to timeline for submission of first financial results by newly listed entities in order to streamline and overcome the challenges in the immediate submission of financial results post-listing. What happens is that immediately after listing, the company suppose a company is suppose the timeline company is getting listed and the timeline for submission of financial results for March is May 30th, and company gets listed say around in mid of May, and it has to comply with LODR and has to submit March results, and it does not have results prepared with it. So what SEBI has prescribed in its consultation paper, that it has given the timeline that company has to submit the financial results within 15 days of its listing, or 45 days or 60 days, whichever is later. So in order to give sufficient time to listed companies to prepare the results. Now, next is with regard to listed companies required to fill up vacancy of directors, compliance officers, CEO, CFO within a period of 3 months from the date of such vacancy, in order to ensure that such critical positions are not kept vacant. This clause of filling of vacancies in the office of KMP is governed by Companies Act, which prescribes for time, which gives the time period of 6 months for appointment from the date of such vacancy. Now, with regard to listed entities, the SEBI has reduced this timeline from 6 months to 3 months. Now, all the vacancies in the office of KMP has to be filled up within 3 months.
Ankit, Can you just explain why this is the need?
I think, sir, a need is, I think, first of all, there was, in case of like company secretaries or compliance officer, where pump fish forms an important part in case of listed entities, it has been seen that the position remains vacant for a period of 4 months, 5 months. And while there was a specific timeline for directors under the Companies Act, there's similar timeline was provided under the LODR, but there was no time frame which was prescribed for appointment of CFO, CEO, or compliance officer. While Companies Act provides for 6 months, but no timeline was prescribed. So therefore, in order to streamline that, they have given a period of 3 months. And what was also happening, that in case of companies which have not appointed these CFO, CS, and at the end of the quarter, when they submit the CG report and they have not complied with these appointments, then generally exchanges asks or sends the notice for show cause or penal action for non fulfillment of the relevant clauses for the appointment, where company then again comes back and provides explanation of 6 months under the Companies Act, and at times there were non-agreement on these points. So I think to give something to the exchanges, also to be clear, very strict about, and for the companies to also follow their strict timeline has been provided. Actual implementation will depend whether the company will be able to file a suitable candidate within this period or not. But now, similar to independent actors, there is also a specific timeline of CFO, company secretaries, or CEO under the LODR.
Okay. Niti.
Yes, this is a good corporate governance move by SEBI, since all these KMPs have their own specialized area, and in the listed companies, public interest is involved. So SEBI wants that interest, each specific person takes care of its area of interest in a timely manner, and appointments are being made as early as possible. So this is again a good move. Now, amendments in ICDR regulations. In case of a underwriting for shortfall in demand or to cover subscription risk is opted by the issuer, the same is required to be disclosed in the offer document prior to issue opening. This is for the IPOs. Now next, listed entities can announce bonus issue of shares only after obtaining approval from the stock exchanges for listing and trading of all the pre-bonus securities issued by it, and bonus issue shall be made only in demat form. Chapter 11 of ICDR regulations governs with bonus issue of shares, which says that bonus issue has to be completed within 2 months from the date of its declaration. Now, what happens is that in case any other, this was the practical difficulty. What happens is that if any of the issue of listing of securities is pending with the exchanges and company announces the bonus, then exchanges cannot give listing approval for bonus issue until and unless it gives listing for the any existing issue, any pending issue, because DNR has to be given in the order only. So this was the practical difficulty because of which bonus issues used to get delay and company has to pay the fine. So now this has been put in the regulation itself. Now company cannot come out with bonus issue until and unless it get its all the pending securities listed. And secondly, second decision is with regard to bonus issue shall be made only in demat form. Currently, what was happening, bonus issue to physical shareholders was distributed in physical mode. Now it has been mandated them even to physical shareholders, it will be made in demat form. Now RTA or company has to open a suspense account, and all the securities which are which cannot be issued, which are to be issued in physical, will be kept in demat in that suspense account, and then shareholders can get it transferred in their account after opening. Next is with regard to extension of timeline with regard to applicability of high value debt listed companies with respect to corporate compliance with corporate governance norms. High value debt listed companies are companies wherein they have their NCDs outstanding for more than 500 crore, or all those listed entities have to comply with Chapter 5 of LODR, which is with regard to disclosure requirement in case of listed entities. Additionally, they need to comply with Regulation 16 to 27 of Chapter 4 of LODR regulations, which is under compliance norms for equity. Now, SEBI has extended this timeline. High value debt listed companies have to mandatorily comply with corporate governance norms with effect from 1st April 2023. Now, it has been extended to 1st April 2024. Since most of the debt listed companies are many private companies, and having not that much of strength to comply with corporate governance norms, since many board of directors have to be appointed, committees have to be framed. So SEBI has extended this timeline to 1st April 2024. Also, to enhance ease of doing business for issuers of NCDs, the disclosure requirement pertaining to interest, coupon, redemption amount are being streamlined and multiple filings are being eliminated. SEBI approved the proposal to consolidate disclosure requirement under Regulation 57. Regulation 57 prescribes for disclosure within 1 working day, within 5 working days of end of quarter, within 7 working days of end of quarter. Now, what SEBI has approved, it has consolidated all these disclosures, and now single disclosure will be made on quarterly basis. And now, with regard to timeline for submission of compliance certificate for structured digital database, NSE and BSE has come out with a circular in which, in case listed entities to whom provisions of regulation 24A are applicable, 24A says about this submission of annual secretarial audit report has to be submitted by the listed entities within 60 days from the end of the financial year. This disclosure compliance requirement with structured digital database has to be certified in this annual secretarial report. Now, for the listed entities to whom this annual secretarial audit report is not applicable, that is listed entities on whom CG provisions are not applicable, now they are required to disclose such compliance requirement and submit SDD compliance certificate by April 21, 2023.
Nidhi, I think you can take it to the ESG.
Yes, sir. Sure.
Thank you. So on February 20th this year, SEBI issued a discussion paper on ESG, where it talks about ESG in connection with the listed entities, with the credit rating providers, ESG rating providers, which they call as ERP, and also the mutual funds, which have mutual fund schemes. And there were proposals in concerns for all three in various respect. And with what appears from the press release, that all the proposals which were discussed or put forth in the discussion paper were approved as by the SEBI in its meeting. Why, Shivam, why the presentation is, why you moving the slides? Hello?
I think Neeti was scheduling it to ESG for you.
Okay.
Yes, sir.
Thank you. So starting with in terms of what is in store for the listed entities, there are two important things. So while we all have been reading these days, everything is all about ESG, and globally there is a recognition about the role ESG is playing in terms of overall business operations. So, and considering the same, the BRSR was also, BRR was changed to BRSR. And from this year, as it will form part of the annual report of the listed entities. So now SEBI feels that since BRSR will play an important part, and a lot of decision makers, ESG rating providers, mutual funds will rely on a lot of information that will be provided as part of the BRSR. They will rely on that information. So therefore, it wants that information to be thoroughly validated and ensure that factual and true information is provided. So therefore, it has proposed for a reasonable assurance for certain disclosures in BRSR, and that a company, while disclosing certain parameters of the as part of the BRSR, will include obtain certain limited assurance on those disclosures. And for that, they have created a set of disclosures which is they are called as BRSR core, and they have outlined the set of disclosures as part of the discussion paper. And these disclosure paper, these will certainly form part of the BRSR. They will amend them in the due course of time. So going forward from year 24-25, the companies on which BRSR is applicable, they will have to disclose BRSR core disclosures as part of the BRSR, and top 150 listed entities will obtain a reasonable assurance from a third party onto the disclosures that are made as part of the BRSR core. In the discussion paper, the glide path started from top 250 listed companies, going forward to top 1,000 listed companies. But I believe in the press release, they have instead of 250 companies, they will be starting with 150 listed entities. So these listed entities, apart from BRSR, will also have to give certain information on the parameters outlined in BRSR core, and which also needs to be validated by a third party in order for a reasonable assurance for third parties who will be relying on those information. These information are basically related to carbon footprint, water footprint, gender diversity in terms of inclusive development, how you engage, friendly engagement with customer and vendors, openness in terms of the business. So under each head, there has been there are quantitative disclosures that are asked as part of the BRSR core. And since this BRSR core will not be required as part of the BRSR, which will be making for the FY23, so therefore in the due course of time, they would be amending, making it as part of the BRSR, and which from effective to 24-25 will be disclosed as part of the annual report, and which will be also validated by a third party validator. Then on the listed entities, there is a lot of discussion on the compliance of ESG norms by the supply chain providers. There are a lot of companies which rely heavily on the supply chain partners, and they form very core of their business. And in true sense, as per SEBI, their ESG norms, meeting of ESG norms by those listed entities will heavily depend upon the norms they would be met by the supply chain. So therefore, currently there are some essential indicators as part of BSR where companies are required to comment on the supply chain, but they are now introducing it also in a glide path manner, where certain listed entities, in case of top 250 entities, they have to also report on the ESG norms compliance by the supply chain partners. From I think from 24-25, it will be on explain basis, and then 25-26 it will be on a mandatory basis. This is what is appearing from the press release. In the discussion paper, 1 year was given as a year of just voluntary compliance, and from next year the compliance will shift to from voluntary compliance to comply or explain, where if you don't comply, you have to give necessary explanations. Then moving on to ESG rating. So there are ESG rating providers. Since ESG rating forms the key part of, again, for decision making for mutual fund who have ESG schemes, and for a lot of investors who rely on these ESG ratings. And as of now, there is no regulated framework for ESG parameters on which this will be rated. There are global standards of ESG. Some jurisdictions, regulators have come out with their own standards on rating. India don't have any rating standard as of now, which is approved by the regulator on the ESG. So as part of the same, SEBI has approved a set of parameters on three components of ESG: environment, social, governance, on which the ESG rating providers have to, which they have to consider while giving their ESG rating. Apart from that, there is also a concept of rating on BRSR core. So ESG rating providers also will require to give a separate rating on the ESG BRSR core, which specified class of listed companies will start disclosing from 24-25, and these ERP providers are also required to separately give a rating on the disclosures made as part of the BSR code. In this will be in addition to the general ESG rating that they will be doing on the parameters as prescribed under the discussion paper. Final fine print will depend upon the amendments made in the LODR or in the respective ESG rating credit rating agencies regulations. On the ESG investing, and then moving ahead, when we comes on ESG investing, there are certain amendments with respect to the mutual fund industry. So first of all, currently mutual fund industry, when they launch a ESG scheme, they launch under the thematic category, which is where a theme-based ESG theme-based schemes are launched, and ESG schemes are launched under that theme-based category, thematic category. Now they SEBI has approved a specific category under the name of ESG category, and where companies can launch multiple schemes going forward. And they have also outlined certain factors where while they launch their schemes, they have to specify under which factor or what kind of scheme they are coming. Then there are certain other amendments, proposed amendments with respect to, in case of such ESG schemes, 65% of their AUMs should be in companies which are mandatorily complying with BRSR core. So companies, they have to make sure that 65% of their AUM is invested in the companies which are complying with the BRSR core. Then they have to give separate disclosures on how they are voting in these companies, the kind of strategy they are following as part of their ESG plan. There are a whole lot of things that the mutual fund industry will have to disclose in terms of the ESG schemes that they're going to launch. So whole lot of thing. If you read the SEBI press release, you will find the whole lot of thing is being approved by the regulator on ESG front, and going forward, this will definitely become up or develop as a very, very comprehensive and interesting area to look into. That's all from me, sir.
Okay, Ankit. Okay.
Mm.
So now,
Thank you, sir. Yeah.
anything is left out from your
Ye-
security?
Yes, sir. Actually, one more decision has been approved by SEBI in its board meeting. It is not mentioned in the presentation. That is with regard to applicability of fundraising by a large corporate. Large corporate is a concept which was introduced by SEBI in November 2018, wherein entities which are identified as large corporate. Large corporates are entities wherein, if in case any of their security is listed, second, in case their long-term borrowing is more than 100 crore, or they have been assigned AA rating or above, then these companies have to mandatorily uh, come out with debt issuance of 25% of their incremental borrowings in any financial year. Now, suppose with regard to financial year March, if any company is identified as large corporate as on March 31, 2023, then that company has to mandatorily come out with the, issue of NCDs, of 25% of their borrowings in the borrowings which they have, which they will be doing in financial year 23-24. They have to mandatorily come out with debt 25% of NCDs, and those NCDs have to be issued in 2 financial years. Now, SEBI has increased this time frame that 25% of incremental borrowings through NCDs can be issued over 3 financial years. Now, those listed entities identified as large corporate will have the time frame up to March 31, 2026 to issue NCDs. This SEBI has increased the time from 2 years to 3 financial years. This is all for SEBI board meeting updates. And now, moving on to operational guidance under buyback of securities regulation 2018. SEBI has come out with operational guidance note wherein it has clarified the amendments which has been approved under amendment regulations, that these guidance under this guidance note, SEBI has prescribed various restriction under buyback through stock exchange route. Since SEBI does not much of a foster buyback through open market route, and it has prescribed various restrictions with regard to volume of shares that is being purchased by the company under buyback through stock exchange routes, bids placed, and price at which the shares are bought back. Under volume, they have specified that the company shall not purchase more than 25% of average daily trading volume of its shares or other securities in the 10 trading days preceding the day in which such shares are to be bought back. Secondly, the company shall not place bids in the pre-open market first 30 and last 30 minutes of the regular trading session. This was the restriction with regard to bids. Thirdly, with regard to price, company's purchase order price should be within the range of plus minus 1% of the last traded price. So all these restrictions were not earlier there under the buyback through stock exchange route. These have been imposed now and is effective with immediate effect. Next, SEBI has come out with guidelines on grant of reward to informant under recovery proceeding. These are the guidelines which SEBI has come out in order to regulate grant and payment of reward to informants who provide original information about the assets of the defaulter. So with an aim to recover fines from elusive offenders, SEBI on 9th March 2023 introduced a reward system for up to 20 lakh to informants for sharing information about the assets of defaulters. The reward under this scheme will be granted in 2 stages. First is interim, next is final. Interim reward amount will not exceed 2.5% of the reserve price. Reserve price is the recovery price, which is being determined by the recovery officer of the asset regarding which information was furnished, or 5 lakh, whichever is less. And at the final stage, which will not exceed 10% of the dues recovered, or 20 lakh, whichever is less. This mechanism is applicable wherein in this SEBI will be prescribing the list of defaulters on its website and which are difficult to recover, and a reward will be granted to an informant who provides original information. This is all with regard to SEBI guidelines. Now, I request Ravi to take up Master Circular on Surveillance of Securities Market.
Thank you, Neeti. The circular comes as a consolidation of the circulars issued by SEBI ever since 2010, particularly by the Integrated Surveillance Department of SEBI on various issues ranging from how to monitor the trading rules and shareholding in dematerialized mode, monitoring of unauthenticated, as we also discussed earlier, unsolicited messages. And then a part of it deals with the system-driven disclosures and how SEBI is planning to move forward in that area. Now, the circular is categorized into different chapters as per the topics it deals with. And the first one of them is pertaining to the trading rules and shareholding in demat mode. So I will just quickly tell some pointers which are covered, which are the crucial key pointers covered under each head. And therefore, it is for all the participants and all concerned to read this circular in detail, because what is seminal about this circular that it resigns almost 13 circulars issued ever since 2010 till September 2022. And all of that has been consolidated in this master circular, all the instructions and prescriptions, whatever were issued in past. So dealing with the first head, it says that companies must achieve 100% promoter shareholding, promoter and promoter group shareholding in demat form in order to trade on the normal segment of the stock exchange. And they say that compliant entities who, and to mind you, these non-compliance would be tested on the parameters of LODR as well as the disclosure obligations that are there on the companies. So if there is any non-compliance pending, the company would remain suspended or in the trade for trade zone until the compliance is met. And then they say for certain transactions which are directed on account of revival or any kind of debt restructuring program, they say that those entities would also be under trade for trade with a price band. And the details and the delineation about the nitty-gritties of all these aspects are given in the circular itself. But it says that for the first 10 days, there will be applicable price bands, and thereafter, on the first day of trading, the price band may be kept open. And then the elephant in the room probably is the monitoring of unauthenticated news circulated by various SEBI-registered market intermediaries. So as we were discussing, some solutions emerged out. It seems that SEBI has also been tracking this issue, particularly as we saw in past, a big case was cracked down by SEBI on failure to verify the rumors or the information which are soliciting in the market, and then it was overturned by the tribunal. And thereafter, we saw all these circulars and main thrust of SEBI coming into this area. What they have said is that they have been observing unauthenticated news about scripts circulated by intermediaries or their employees or the people who are associated with intermediaries, or they claim that they are associated with intermediaries. And these are done without adhering to the proper cautions and internal controls or the code of conduct prescribed in that regard. So they say in order to prevent any damage, and there was one question raised by a gentleman who asked why to pay attention to the rumors. Maybe from an individual perspective, rumors might appear as a trivial matter or a matter which one should not pay too much attention to. But see, from the regulator's perspective, a rumor may be very damaging for the market, because after all, the market functions on information and how people perceive that information. And the rumors are designed to alter the information, not only the information, but also the perception. So therefore, it becomes very important for the regulator to ensure that rumors are not there in the market. So they have said, the SEBI has said that they must, intermediaries today, and that's a reality check done by SEBI. I must say that we, as a developed securities market, we should have had better systems at place, because it's a fairly old market now. But SEBI says that intermediaries do not have that kind of systems which can prevent rumors and which can control these kind of unauthenticated activities in form of solicitation. So they said they have issued a en masse direction to all the intermediaries that they should keep their internal control systems robust, and they should keep a check on their employees, whether they are forwarding or they are accessing even through social media accounts or other VIOPS, these unsolicited messaging. So they have said that logs of such media usage must be maintained. So that would be interesting how these intermediaries would control or maintain logs of the usage of social media accounts by their own employees or consultants, or even on the people who are not under their control, but they somehow deal with them. And a word of caution has also been given for the employees, because ultimately SEBI has made it clear now, at least by this circular, that if we find any unauthenticated news or solicitation being done by any person, regardless of taking an action on the systematic level, that whether organization had an internal control system or not, that's a secondary matter. But the first violator would be the person who would be soliciting those kind of rumors. So that's another head which was on the unauthenticated circulation of information. The third one is focused on PIT regulations, where they are talking about system-driven disclosures and strengthening the need of having a robust code of conduct and how it should be reported, how the violation should be tracked and reported to the stock exchanges. And then they have expanded the scope of automation of the disclosures, which were earlier applicable on promoters and directors. And those are now being extended to the promoter group person and designated persons. That step has already been taken since September 22nd onwards. But as this master circular consolidates it all at one place, I'm just saying that what all instructions have been given here. So therefore, it is very important that all the compliance officers, all those people who have something to do with the intermediaries registered in the securities market segment, or they work with listed companies, it will be beneficial for them to go through this circular, probably make their checkpoints for the compliances or the actions that they're going to take in the future. That's about the circular. Now, I should move towards the legal precedents or the developments in the judicial corridors, which happened in March. So the first case is of a debenture, a dispute pertaining to one of the Reliance Group entities which went into liquidation, and how it was revived through negotiations in High Court through a resolution proposal by banks and the ICD holders. And there is a case of Rajkumar Nagpal in which a similar kind of issue had arisen before. I would not touch upon the issue because Madan sir may take it up in detail later on. But they said that merely because SEBI has, so we all know that debenture trustee as a concept is regulated by SEBI, and this host of circular issued even the procedural guidelines with respect to voting in case of a debenture trust. So in this dispute also a debenture trust was involved, and the controversy was whether the voting done in contravention to the SEBI circular or by not following the SEBI circular strictly can be recognized. Therefore, the matter reached Supreme Court, traveling through Bombay High Court, and the Supreme Court said that we dealt with this issue, and in cases of liquidation, we would see what is the ultimately realizable value and how it would benefit especially the retail participants. So they said, see, circulars, if we go and apply the circular in its strict sense, it might not realize the value for the retail participants, and therefore it would cause more damage than good. So therefore, they said the issue was earlier determined in Rajkumar Nagpal, and they laid down the principles and said that nothing doing, we're not going to, merely because a circular has not been applied in its strict sense, we're not going to overturn the negotiated settlement arrived before the High Court or the courts. And that's what they did, but they have indeed opened a window for those debenture holders who had either not participated or voted against the proposal, that their legal recourses would stand open. Second is the release of 5,000 crores ordered by Supreme Court recently on March 29th by a bench of Justice M.R. Shah and Justice C.T. Ravi Kumar, where they have recognized that SEBI has got unutilized amount of 24,979 crores and 67 lakh rupees in the Sahara SEBI refund account. And they said that out of this, they have identified some depositors who deposited money through various cooperative societies of Sahara and Sahara-controlled entities. So therefore, a direction has been given that out of this 24,000 crore rupees, 5,000 crore rupees should be transferred to the Central Registrar of Cooperative Societies. And then they have constituted a committee for repayment of this money, for identification of the depositors and repayment of this money to them. And they have made a panel of retired Justice R. Subhash Reddy, who was a justice in Supreme Court, and along with one advocate who has been appointed as amicus curiae for the court. And these people in consultation with the Registrar for Cooperative Society, and I'm saying consultation not in the sense that the judge has to consult, but judge would head the panel, the registrar has to consult, and they would together decide the modalities of payment. And whatever money would be would remain unutilized even after making payments to these who were depositors, that will be remitted back to the Sahara SEBI refund account, which stands at whopping 24,979 crores. Then there is another matter where SAT has again come down heavily on people who do not attend to the summons of SEBI. It was a matter concerning one of the GDR issues. Those who follow the securities market, they know that there was a huge allegation on all these GDRs which were done between 2007 to 2010, and the SEBI, in all probability, held that each and every GDR was a sham, or most of them were sham, and they punished almost all of them. In this one of those cases, the issue was whether a person who was not a director when the transaction had happened, but became a director later on and a managing director, and then received some summons from SEBI, whether he is bound to respond or not, or whether the excuse that I was not aware of the information or the transaction, or I was not in the company at that point in time, would be a valid excuse to not attend to summons or to appear before SEBI. SAT categorically said, referring to the provisions of 11C subsection 3 and 11C subsection 6, that he was duty bound to cooperate in the investigation, and for the failure to cooperate in the investigation, a penalty of 10 lakh was levied. Aggrieved by that order, they appealed to SAT, and appeal confirmed the findings, relying upon an order which was passed in 2011 already in a similar case. Subject matter was different. I say it's similar because charges of non-cooperation were there. And the case is Asian Films Production and Distribution Limited versus SEBI, appeal number 203 of 2010, decided on 19th January 2011. So they said it's a well-established position that as a regulator, SEBI has to manage the entire market, regulate the entire market, and the non-cooperation in investigation can't be looked at leniently. And they say that you should have attended to the summons, whatever be it, whatever your role was, whatever little assistance you could have given, but you would have attended to the summons. That was a prerequisite. And therefore, by not doing so, you contravene the provisions of law, and therefore they did not interfere with the penalty. Another matter is again by Supreme Court, where the issue in summary was that a person who was registered as a stockbroker in his individual capacity transferred his membership card to an incorporated entity and was claiming waiver of fees on the ground that the further fee should be adjusted from the fee he had already paid. But this gentleman was not a whole-time director in the newly incorporated company to which he had transferred his individual membership card, and he was therefore not complying with the conditions laid down in Schedule 3 of the Stockbrokers Regulation and its Clause 4. So therefore, the limited narrow point of law was that whether he stands compliant with those conditions or not. SEBI found that he was not complying. SAT upheld the finding of SEBI, and Supreme Court also seemed to have leaned in the favor of SEBI and SAT, saying that he did not stand compliant and rejected the appeal. Now, there's again very important matter. I'll take 2 or 3 more minutes to conclude this. There was recently a case wherein, and it's a sensational case, widely circulated in all social media platforms. It's called as, famously known as pump and dump case. Now, there, a famous actor, Arshad Warsi, who was circuit in Munna Bhai MBBS, just to give the context, he was also alleged to have participated in this fraudulent scheme. So therefore, he appealed against this order, which was an ex parte order, which banned him from the market and raised a demand or an attachment order, a quasi-attachment order, that if you do not deposit this money, your bank accounts and all the assets would be attached. And the attachment was coming about somewhere 3 to 4 crore rupees, considering him and his connected entities. He appealed in SAT, saying that how this kind of an ex parte order be passed without allowing me to join the inquiry, or without asking me or confirming with me the facts which SEBI has relied on. After a long-drawn argument in SAT, the following propositions were argued. One was that whether is it merely on presumptions? An authority like SEBI can pass an ex parte order. So SAT said, no, it cannot be on presumption. It has to be on the preponderance of probabilities for which detailed tests and safeguards are laid down in various judgments of Supreme Court. So they said it can't be unless until a role or a prima facie role has been found connected to the fraud executed in the securities market. But what was surprising in this order is that because there was an allegation on Mr. Varsi, and because SAT found that at this initial stage, we cannot rule out your participation in the fraud. That can only be examined when the investigation is complete. And since the investigation is ongoing, some material might surface which may show your indulgence in the fraud. So therefore, although they set aside the order, they have subjected him to the investigation, directed SEBI to conclude the investigation in 6 months' time, and also directed him to deposit 50% of the demanded amount, with an undertaking that he would demand the remaining balance as and when the order is passed. Of course, if the order is against him, upholding the charges of fraud on him. So these are the principles on which this case was, the decision was rendered by SAT, primarily, which is that no apparent connection at this stage with any of the fraudulent persons, and assumptions and presumptions taking place of evidence, whether direct or circumstantial, in the examination done by SEBI. So on these two contours, SAT weighed the case of SEBI, and then passed a decision. This decision was rendered on 27th of March. That's all from my side today.
Okay, thank you, Ravi. Thank you very much for giving detailed analysis of recent cases also. Now we have various, because insolvency law, there was no updation, but some few case law. So I request Manoj and GP Madan, please take up. The first case was on whether lease premium amount and the lease rent are included in explanation appended to section 14(1)(d) of IBC. That was one case. Second case we will discuss today. Corporate debtor and financial creditor who does not attend the CIRP cannot be heard in saying that process was wrongly been concluded. And then E-Homes Infrastructure Private Limited, appellant versus Noida, New Infrastructure Private Limited, principal bench. These are the three important case law. So I'll request GP to please take up the first case, whether lease premium amount and the lease rent are included in explanation appended in section 14(1)(d) of IBC. Over to you, Madan.
Thank you, Pawanji. First of all, I would like to take you to the genesis of this provision of moratorium with respect to the expenses during CIRP. The genesis goes back to the year 2017 and 18, when there were two judgments pronounced by Honorable National Appellate Tribunal, first in the case of Rajputana Properties and another in the case of A&G Industries Limited, where the law was laid down that if there is any creditor or a service provider whose dues are outstanding to the corporate debtor, for all those outstanding dues, the payment shall be made, they have to file a claim with the resolution professional. But whatever expenses are to be incurred, particularly with respect to the essential supplies, for all those essential supplies, the payment has to be made for the CIRP period supplies. And if the payment is not made, then these essential supplies can be discontinued. Then taking a cue from these two judgments, section 14(1) was amended and an explanation was provided. Number one, to provide clarity to this judgment, these two judgments, and number two, to widen the scope of moratorium. What shall be covered in the moratorium and what shall not be covered in the moratorium. So in that case, if we read this explanation, it says that the prohibition of recovery of any property by any owner or lessor, I'll read from here. For the purpose of this section, it is hereby clarified and notwithstanding anything contained in any other law for the timing in force, a license, a permit, registration, quota, concession, clearances, or a similar grant or right given by a central government, state government, local authority, sector regulator, or any other authority constituted under law for the time in force, shall not be suspended or terminated on the grounds of insolvency. It means if there is a license, permit, registration, quota, concession, or any clearance is there, these shall continue. These shall be considered as essential supplies. Simply because company has gone into insolvency, the quota shall not be withdrawn. The registration will not be cancelled. License shall not be suspended. That is what the clarity has been provided. Insolvency will not have any impact on these. Reason being, the objective of the law is that the company should remain a going concern. So if the registration, license, or quota is suspended or be withdrawn, the company cannot remain a going concern. The company will close down the company. Then there will be no other option but to liquidate the affairs of the company. And for this purpose, this explanation was provided. And then subject to the condition that there is no default in payment of current dues. Now, this is emanating from those two judgments which I just discussed, Rajputana Properties and AMG Industries Limited, that for every supply during CIRP, the payment has to be made. Then only these supplies will continue. So even if there is a license or quota or registration and there are certain recurring expenses with respect to this license, quota or registration, those recurring expenses during CRP period have to be paid. Otherwise, this registration, license, quota can be suspended or can be denied, can be withdrawn. Now it goes further. That suppose subject to the condition that there is no default in payment of the current dues arising for the use or continuation of the license, permit, registration, quota, concession, clearance, or a similar grant or right during the moratorium period. Now, this is the crux of this particular order, which we are discussing right now. It says, or similar grant or right during the moratorium period. Here, Noida had given a land on lease. Now, Noida says that I want my leasehold rights. I want my rental for this period. When the company has gone into insolvency, land is on lease, there are certain lease rentals. I want these lease rentals because the moratorium is not applicable to this. I have the right because, but the other party says, sorry, for all these running expenses, what has been excluded from the moratorium is the license, the quota, the registration, concession, or clearance. But these lease rentals are not part of this. Then the court clarified that a similar grant or right, these words which have been used, similar grant or right during the moratorium period, are in relation to license, permit, registration, or quota. This similar right or grant is not applicable to lease rentals. So therefore, ultimately the appeal was of the appellant was dismissed. I think this is Sunil Kumar Agarwal was the appellant, and tribunal, I just read you the concluding para. Tribunal surmise that a similar grant or lease right has to be read in respect of license, permit, registration, quota, concession, clearance, but it cannot be read as the premium amount or lease rent which has been so ordered by the adjudicating authority to be paid by the appellant to the respondent. So the order of the adjudicating authority was set aside in this case. Actually, adjudicating authority in this case said that you have to pay the lease rental. But ultimately, appellate authority said, sorry, this is not covered by this. The appellant, that the resolution profession, is not bound to pay these charges, this lease premium for the CIRP period. So this is the clarification, actually, to be very frank, this is a clarification which has been provided to the words similar grant or right. This is not, cannot be made applicable to any right or any grant, but it has to be read in relation to license, permit, registration, or quota or concession. Manoj, your views on this?
Manoj, you please.
I believe, yes, the interpretation is correct. Lease rental, here the thought is Noida authority, so it appears that it is a central government, state government, or local authority. But this lease rental can happen, can be from anyone, any private party also. So if it is extended there, then all the rentals, etc., need to be paid during the CIRP process, which will be a very difficult situation, and obviously it will be very difficult for us insolvent company. So judgment seems to be in right direction for survival of the company.
But on the other hand, on the flip side, Manoj, if we read the Rainbow judgment of Honorable Supreme Court,
right?
Rainbow Supreme Court said that if the dues outstanding to central government, state government, any statutory authority, any legal authority, or to any other authority, if those dues are not paid, if those dues are not provided for in the resolution professional, then resolution plan, if not provided, then the resolution plan is illegal, has to be set aside, has to be quashed, and the company will go into liquidation.
Yeah. So
if we apply that formula here, if we apply Rainbow here, then the dues outstanding to Noida authority have to be paid.
It has to be paid as part of the plan, but during the period of CIRP, it may not be paid. It has to be made. Some provision may need to be made. What provision it will be, that will depend upon the resolution plan.
It means the clarity is there. No need to make these payments, but make them as CIRP cost. So if you do not make these payments, this lease cannot be terminated. The lease will continue till the time either the resolution plan is approved or till the time the company is liquidated.
Yes.
The lease will continue. That is the crux of the matter.
Right. So whatever business are essential to continue the business, to make the business going concern, should be considered as a CIRP cost and placed there, so that there is no dispute at all. I think this discussion was also in the Reliance communication matter, where government was trying to take away the this 2G license from the company. If the license goes, then what is the purpose of revival of the company or survival? There was no possibility of company getting revived. So obviously these are essentials, and if you want successful CIRP, then those licenses, quotas, etc., need to be restored, need to be continued, right. And precondition of payment cannot be there.
You're right. Yeah, can we come to the second judgment now?
Yeah, madam. Second, now come to the second case. So
this we have covered. This has been covered.
We have covered. Next page, yeah.
Corporate debtor and financial creditor who does not attend the CIRP cannot be heard in saying that process was wrongly being conducted. Now, first of all, you have not attended. Second, now you are complaining. So the decision is right, but what are the fallout of this, and why the people are not attending?
No, this is a perfect order. I mean, absolutely in line with this order. What has happened in this case? This particular appellant, who was a financial creditor, he is part of COC. There are 16 COC meetings during this period of CIRP. He attended just one COC meeting. 6 expressions of interest were invited. When there are 6 EOIs, this particular financial creditor had a right all the time to submit a resolution plan. Once this plan is approved, now he files a preference and appeal that CIRP process was not implemented legally, or there were certain flaws by the resolution professional during the CIRP period. I want to file my resolution plan, and my resolution plan should be considered, and the resolution plan which has been approved by the COC should not be considered. Court says you had ample opportunities to submit the resolution plan. You had ample opportunity to raise your objections during the CIRP period. You have not exercised your right. At this stage, if you are filing any application, if you are raising objections to the resolution plan or to CIRP period, this is nothing but an exercise to derail the resolution plan approval process. And if your intention is such, then certainly the court is not with such an applicant or appellant. Court said you have not come with the clean hands. You had ample rights. You had ample opportunity with you. You failed to exercise your rights. You failed to encash those opportunities. Now, certainly you cannot be heard at this stage.
I think, yes, it is a very correct judgment and very important to make it clear that no action, no steps should be encouraged, which are just to derail the process of CIRP. Otherwise,
Yes.
obviously, the whole purpose of IBC would go. So, yes, it is a very correct judgment. Whoever is party to COC or can be a contributory must be vigilant, must take prompt action as per the timelines, and then only their interests should be protected. Otherwise, no post facto derailment or applications should be entertained by authorities.
Yes, Pavanji, we can come to the third case.
Now, this is what are the important thing in this case law, Madan?
What has happened in this case? The Noida Authority has given a land on lease to one company called Logix. Now, if you grant a lease, certainly there are certain terms and conditions to be complied with by the lessee. And if the lessee, no doubt, lessee has a right to sublease this property to others. But while doing this sublease, there are certain permissions or approvals which are required to be taken. The rights of the lessee cannot be transferred to sublessee. What happened in this case? The lessee, the Logix, signed a sublease in favor of another company called Neo. And then what happens further? The sublessee, that is, Logix, sublessee Neo, and another company, Bryce, they enter into some sort of collaboration agreement. I'm repeating it. Noida gives a land to the lessee. Lessee does a sublease. Now the lessee, the sublessee, as well as another company, they enter into some sort of collaboration. Let's call them A, B, and C. A is lessee, B is sublessee, and C is third company. A, B, C enter into some sort of collaboration agreement. And as we know, some collaboration agreements are there, or some joint development agreements are there. Now this company B and C, the sublessee and the third company, they go into insolvency. If they go into insolvency, then there is one resolution applicant, one single resolution applicant. First of all, in case of B and C, there was one single resolution professional. One individual was there who was a resolution professional in the case of B and C. Now there is one resolution applicant who submits two resolution plans. One for B, another is for C, absolutely fine. But the plan of C is dependent on plan of B, and plan of B is dependent on plan of C. C shall be subject to the implementation or approval of the plan B, and B plan shall be subject to the approval and implementation of plan C. Court considered it as a consolidated resolution plan. Now to this plan, Noida raised an objection that there cannot be a consolidated resolution plan, number one. Number two, when these two companies go into insolvency, the land which is given to the lessee, actually that is part of these resolution plans. We have given it to the lessee. If the lessee has entered into some joint development agreement, or lessee has entered into some collaboration agreement, and those other two companies, they go into insolvency, the land of the lessee cannot become part of those resolution plans. The land belongs to the lessee, and the leasehold rights are still with the lessee only, and unless the lessee clears all the outstanding dues of Noida, this land cannot become part of the resolution plans of any other company. So these two objections were there of Noida. Noida went to appellate authority and raised objections. Actually, first of all, Noida went to adjudicating authority. Adjudicating authority didn't listen to the. Now Noida prefers an appeal. Okay. And in this case, what has happened? On 30th of January 2023, same chairperson's court of NCLAT has passed a detailed order of, I think, 190 pages in case of Earth Infrastructure Limited. This judgment is based on that judgment only. What happened in Earth? Incidentally, I was a counsel for the resolution professional in Earth. What happened in case of Earth? The Noida allotted land to Earth. And one of the conditions of the allotment was you create an SPV, because it was land was allotted to Earth Consortium, Earth plus two other entities. One of the conditions of the allotment was that this consortium shall create a SPV. Lease shall be done in favor of SPV. It was done, and then the lease deed was executed in favor of SPV. Similarly, there was 5 different subsidiaries or SPVs by this corporate debtor, by this our parent company. 5 different companies, 5 different projects. And the 5 different companies, all are 5 subsidiaries. Now, this parent company, Earth, goes into CIRP. And the resolution plan is submitted. Actually, the plan is for the subsidiaries. And what has gone into insolvency is the parent company. Subsidiaries have not gone into insolvency. But now the plan is submitted. Resolution plan is approved by the adjudicating authority. At this stage, Noida authority challenges the resolution plan. Approval order of adjudicating authority. NCLAT says that the land was allotted to the subsidiary. Subsidiary has not gone into insolvency. If subsidiary has not gone into insolvency, the assets of the subsidiary cannot become part of the resolution plan of the holding company. Therefore, the resolution plan approval order was set aside. Greater Noida, this Noida authority was asked to submit its claims again to the resolution professional. CIRP period has to start again. 6 months period was granted to the RP. Now, this order of NCLAT, 3 appeals have already been preferred before Supreme Court. All those appeals are pending, likely to be listed on 17th of April. In this case also, I'm pretty sure appeals shall be preferred against this order of NCLAT. If time permits, I would like to read a particular paragraph which has been quoted in Earth and has been quoted here also. That's very interesting for all the professionals while dealing with this holding subsidiary relationship. It says the resolution plan does not confine itself to development rights which were granted by the land owning company in favor of the corporate debtor on an unregistered agreement. So this is JD or collaboration agreement, say it's an unregistered agreement. Now, not only rights in the land have been transferred, but this agreement also contemplates transfer of title of land in favor of successful resolution applicant. Well, how can it happen? When parent company is not having ownership rights, how can you transfer ownership rights in favor of the resolution applicant? That's practically impossible. The development agreement, which was unregistered document, could not have dealt with any right in the project land, and the leasehold right as per the development agreement continued with the lessee. It cannot go to any other company. Hence, the resolution plan could not have provided for transfer of leased land in favor of successful resolution applicant. Admittedly, the appellant was not party to the development agreement, means Noida authority was not party to development agreement. So tripartite agreement yahan bhi hua. In the tripartite agreement, Noida is not an authority. And this development agreement was executed between land holding company of the CD, the appellant means Noida, not being the creditor of the corporate debtor nor stakeholder in the CRP resolution plan, could not bind the appellant in any manner. So whatever is the arrangement between the lessee company and other companies, or joint development agreement or collaboration agreement, all the terms of those agreements are not going to impact the rights of the lessor, that is Noida or Greater Noida Authority. It is also relevant to notice that development agreement, being an unregistered document, could not have transferred any right in lease or land in favor of the developer. Appellant not being party to such development agreement, the same is not binding on the appellant. See, on similar analogy, in this case, appellate authority has decided that there is a resolution plan with respect to two entities who do not own this land. This land is owned by a lessee. Lessee is not into insolvency. Therefore, all these, both the resolution plans, which are conditional, which are interdependent, are illegal and cannot be approved. And in these cases, friends, I would like to share with you that certain strictures are being passed in these order against the resolution professional also. And once a stricture is passed in against the resolution professional in any of the orders of the adjudicating or appellate authority, I tell you, our regulator, IBBI, is very seriously takes up these orders and immediately issues a show cause notice and starts disciplinary proceeding against that particular insolvency professional. So whosoever is insolvency professional attending this webinar today must take care that whenever you place a resolution plan before the COC, please ensure that a plan is as per law, does not violate any of the provisions of the code or the regulations or of any other law for the time being in force. That's my humble suggestion to all of you.
Madan, there is one question for you and Manoj. A company owned by direct government is under CIRP. Whether the government can affect transfer of its ownership to another government during pendency?
A company owned by government is under CIRP. Okay, whether the government can affect of its ownership to another during pendency of what?
So CIRP process does not stop the transfer of shares in any case.
No,
whether it is a listed company or unlisted company.
Manoj, the question is, government is under CIRP. The companies.
Company is under CIRP and its ownership is
CIRP.
getting transferred. So ownership is shareholding basically.
No. It cannot be done without the permission of the COC. Section 28, subsection 1 applies.
No, but asset is not transferring. No,
asset is not getting transferred. Only shareholding.
No control, no management of the company can also be transferred during CIRP. Section 28, subsection 1 is
there is no change in control because it is a government company to government company, and it is a share transfer. In case of listed company, trading happens daily basis.
Sorry, not according to me, not allowed. You have to seek the permission of the COC. Without the permission of COC.
But what happens to all listed companies? Their trading is happening on daily basis.
Listed, unlisted. Okay, that's very important. Very important issue you have raised. That happened with me also in one of the listed companies. One of the bankers who was holding some shares, he wanted to transfer the shareholding.
Yeah.
The matter was brought before the COC. COC clear-cut said, is this amounts to change in the management of the company. Change in the management cannot take place without the permission of the COC, and COC declined it. So if it is so now I'll say that if it is a share trading of public share trading can happen. But if the share trading or transfer of hands of shares of the promoters or the management, that cannot happen without the permission of the committee of creditors. That is why I always say, Pawanji, if you remember last time I gave this suggestion that for this purpose, a separate window should be created for all those companies into CIRP. So the public comes to know who is the buyer, who is the seller, and there should be some sort of restriction on sale and purchase of shares of these companies which are under CIRP.
Okay, but
that is a big challenge for SEBI. This discussion has happened several times, but SEBI cannot take any decision on this because let's say admission into CIRP happens suddenly. So there may be thousands of shareholders who are stuck there. If you stop normal trading, then there is a very high chance that they will not be able to exit from the company, or this can be a big challenge. It is not in the interest of the small shareholders. So SEBI is not taking such harsh decision to stop the trading or make a separate window of trading for that.
I'm not saying stop the decision, stop the trading.
Irrespective of what, like it will be like some dissemination board or something, separate board where you can sell or purchase the shares. But that they don't want, because it will create a chaos if in case of large size companies.
No, I tell you, the moment IRP is appointed, the IRP is duty bound to intimate to all the authorities, including ROC as well as exchanges.
Yes.
The moment ROC receives this information, ROC simply writes on MCA portal companies under CIRP.
Yes.
Similarly, stock exchange is also should be mandated to take some action, and that's why I'm saying that separate window should be there for.
No, they put.
I'm not saying stop the trading. I'm simply saying have a separate window, separate portal for all those companies which are under CIRP. Like you have the different categories, S category or Z category or this category or that category. Similarly, you can have if you don't have separate portal, have a category for CIRP company.
Yeah. So as in case of GSM, ASM, they put IRP against the company's name. So that is there, and you can understand that this company is under insolvency. That intimation is given on the website of the stock exchanges. But trading happens in the normal segment, and there is no stoppage, because sometimes the matter can drag on for 2 years. So and later on, let's say it is reversed, a company becomes a normal company, then this is a very chaos situation. Where to stop it? So I think this proposition may not work.
Which proposition?
Yes, that stop the trading or keep a separate window.
Nobody's saying stop the trading. I'm against suspension of trading. I'm against it. I never said trading should be suspended. Trading should rather, there's some suggestions to SEBI that the trading should be suspended. Trading should never be suspended. There should always be some exit route.
Yes.
There should be some buyer and say somebody wants to buy the shares of this company, let them buy. Sometimes you may have fortune out of this. But recently we have seen in JP Info also, what has been provided to the shareholder, just 16 lakhs of rupees.
Yes.
During the entire 6 years, the share was kept on trading. 2 रुपए से लेके 4-5 शेयर में trading होता रहा. लेकिन अब जब से कंपनी का रेजोल्यूशन प्लान अप्रूव हुआ है, डाउनवर्ड फ्रीज ही नहीं खुलता उसका, क्योंकि शेयर आर नॉट गेटिंग एनीथिंग. और शेयर लगता जो कुछ मिल जाए ले लो, लेकिन now that opportunity is gone.
Okay, friends. Now time to wind up. There are some few questions. I think one person has given suggestion that why only few names are there for ID, why not the chartered accountant, company secretary, who they can do good work, they should be on the board. I think the person who has asked question, I will just tell, it is on the company, because every company wants a person, either they are close, or if they are not close, they will try to get the person who has some brand name also. So by getting a education or by getting a degree of CACS, you can't become brand. So every company follow the principle on brand. So I think this suggestion is okay, but it is upon the company whom they want to appoint. The question which I have asked, because
may I give my comment on this?
Yeah.
May I ask all those company secretary of the large companies, how many times they have given this suggestion to the board that while appointing an independent director, the chartered accountant or the CS professional, they should be considered? This is
a question they can refer, but you can't know that data and you can't get that information. But my question is that the last question which you or Manoj were differently. So what is the solution? Whether you can transfer the ownership or not? Madan is no. Manoj, you unmute yourself, Manoj. Manoj, unmute.
Yeah, so Madan sir was talking about section 28, regulation 78, which says that there should not be change in control. But I believe the question was relating to transfer of shareholding from one government entity or government to another government department within the government. So there is no change in control. and hence this should be allowed. There will be no restriction on within the group transfer.
Okay, okay. So now it's a time to conclude this today's webinar. Friends, we are trying to bring out, this is a very important session every week, every month, that if you are not able to read or attend or not discuss in detail, this is a golden opportunity that every week, first Friday, you can come on company law, security law, and the insolvency law. Whatever new amendments, changes, and law, you can participate and you can get all the knowledge. So we are giving in a presentation form the changes. Simultaneously, we give our opinion also and discuss with the expert also that what will be the repercussion of this. So you participate in this and it will be useful for all and you can update yourself. So thank you very much. Thank you, Mr. Madan. Thank you, Manoj. Thank you, Neeti. Thank you, Ankit, for participating for today's, and thank you, Ravi, for participating and giving updation. So what, if you want any changes in this, you please tell us. And one more thing, friends, we are completing 3 years on 28th April, and it's a coincide that we are completing our 125 webinar also. So now we are going for phase version 2 of CP webinars. So whatever suggestion you have or you want to give, you want to change the model, process, the format, the speaker, the style, you are free to suggest us. We will definitely implement and we will definitely use it. So thank you very much. Next Friday is 7th.
Pamanji, I must compliment you for this selfless efforts for last 3 years now. I think you are discharging, we talk about corporate social responsibility, other responsibility, but you are discharging your professional responsibility religiously and sincerely for the cause of the profession and the professionals. And you have that you will provide latest updates, education to all the professionals. And this is not education, not confined, I say, to the participants, but later on when everything is hosted on the social media channels also, anybody and everybody whosoever wants to take advantage of this, certainly these are available to them. And I tell you, many a times when I get myself registered, I miss these webinars. In the morning while having a walk, I just open these videos, having a Bluetooth speakers in my ears, and I keep on listening to them. It's a wonderful platform. Kudos to you and compliments to your entire team.
Thank you very much. It's a team efforts which we are doing. Yeah, consistency and persistence is required for making anything successful. So please give your suggestion. It will be very useful. So thank you very much. Next Friday is a Good Friday, and that is a holiday. So we are not having webinar on 7th, and we will meet you in the next Friday, that is 14th, and we will discuss and we will inform you the topic and the speaker. Till then, thank you very much.
But 14th is also a public holiday, Pawanji.
Which, for what?
That is the Mahavir Jayanti, Baisakhi and Ambedkar Jayanti. That's also a public holiday, I think.
Okay, we will just check this and we'll inform to give our participants.
Yes, please. Thank you.
Thank you.
Thank you.
Bye.